Welcome and thank you for joining Seyfarth's webinar, New York Employment Law Update, Review of 2021 and Outlook for 2022. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature in WebEx. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. This time, I'd like to turn the program over to Rob Whitman. Rob, you may begin.
Thank you, and welcome everyone, and Happy New Year. This is our annual New York Update program. We do this in January to take a look back at the past year, developments in employment law for New York employers, both New York City and New York State, and also take a look ahead to see what 2022 has in store for us. And it has certainly been a busy time for everyone. We will be talking about COVID, of course, and there have been a tremendous number of developments on that front, but also quite a bit of activity legislatively in a number of other areas as well. So we've got a lot to go through today, so we can get right to it. You can see the speakers. I am a partner in our New York labor and employment law practice, along with my partner, Rob Zibba, also in New York, and two of our outstanding associates, Marlon Duro and Daniel Small. We will cover the following items. Next slide, please. To just give you a sense of what we're going to be discussing today. I will deal with the first several topics, some wage and hour developments briefly. There have been some new enactments on email and phone monitoring, use of artificial intelligence in hiring, and provision regarding salary range in employment advertising. Then I'll turn it over to Daniel, who will talk about all things COVID-19, of which, as I said, there's been quite a flurry of activity in the last 30 to 60 days. Rob Zibba will then take it over to discuss some updated whistleblower protections in New York that are a pretty significant change in the law in that respect, as well as some changes to the New York City Fair Chance Act. Marlon will then discuss updates on leave law, including COVID-related leave. And then finally back to Rob for some guidance on cannabis legislation. So as you can see, there's really quite a bit of activity for New York employers. So it's understandable if your heads are spinning around this. Next slide, please. First, in the wage and hour area, just very briefly, you may be aware of this already, but just so you have it, changes in the minimum wage took effect on December 31st. For New York employers. As you may know, it depends on the size of the employer and the location of the company. Really, there's only one portion of New York State that's now under $15 an hour, and that's outside of the New York metro area. Any employer is at $13.20. Everyone else is at $15. There has also been, for hospitality employers, a change in the tip credit. If you need information on the specifics of that, just drop us a note in the chat and we can get that to you offline. Next slide. There have also been changes in the threshold for exempt status under New York law. These are on top of the requirements under the FLSA. And once again, as with the minimum wage, the salary threshold depends on the size of the employer and the location. All of these numbers, all of these salary minimums are higher than under the FLSA for outside of New York State. And so it's important, it's easy enough to keep up with the minimum wage, but one thing we have found is that occasionally employers have neglected to take a fresh look at their exempt employees and the salary levels for them at the turn of each new year. So for New York employers, it's important that you stay on top of that. Next slide. So in terms of legislative developments, there have been a number in a variety of different areas. And the first one I'll cover is on email and phone monitoring. This is a new law that applies throughout New York State. and it takes effect on May 7th. And it provides that any employer that monitors or intercepts employee email or other electronic transmissions must provide written notice upon hiring. Importantly, it's just a notice provision. It does not restrict or limit in any way the employer's ability to do the monitoring. It just provides that notice must be given so that employees are aware of it. There's also no corresponding right of the employee to object to this or to exempt themselves from it. Again, it's simply a notice provision. Interestingly, there is no provision in the law for direct notice to current employees as there is for new hires, but there is a posting obligation. So starting on May 7th, wherever you post your usual workplace notices, there will be a required notice on email and phone monitoring as well. And the statute does not restrict things that your IT department does on the back end with respect to just managing the system or making sure that the system is maintained and protected and secure. It's also notable there's no private right of action under the statute. It's enforceable by the state attorney general with some civil penalties, but no actual private right of action. So this is not one that we expect to be a source of significant litigation. Next slide, please. The next area concerns the use of artificial intelligence in hiring, and this pertains to New York City employers, so only within the city, not the rest of the state. This takes effect in about a year, January 1st, 2023, and it prohibits employers and agencies from using AI tools to assess job candidates unless there has been a bias audit that was conducted within the previous year. The employer is not required to do the audit. Typically, that would be done by the software provider or whoever develops the AI system, but the employer will be liable for violations. Again, this is not a prohibition on the use of the tool. It simply requires that the bias audit be done before the tool can be used. And for employers hiring candidates who reside within New York City, they must provide notice to them that the AI tool will be used to assess their candidacy. And the candidate does have the option to request an alternate process, which we're not sure exactly what that means. We expect some guidance from the city sometime in the next 11 or so months before the law takes effect. But what it might be read to provide is that a candidate can say, I want a human being to review my application and assess my candidacy as opposed to some electronic tool. So keep your eyes out for that. We will certainly be monitoring developments closely on that since it could be a significant impediment or change to the way employers conduct their hiring process. Next slide, please. The next development is another New York City statute that pertains to disclosure of salary range in employment advertising. This is a law that likely will take effect in April of this year. There's one more day for the mayor to veto it. There's been no action as of this morning when I last checked the city council site. If the mayor does not act on it, then the law will take effect, and tomorrow is the deadline. So we expect this law will go into effect and will be effective in April, and it provides that any advertisement for a job promotion or transfer opportunity must provide the minimum and maximum salary range that the employer in good faith believes will apply to the position. This is a pay equity based law. The theory is that by disclosing the minimum and maximum salaries, that will have the effect of helping to equalize or eliminate any gender-based disparities that might pertain to a new position. It's in the form of an amendment to the city human rights law, so there is a private right of action And we expect that there will be some regulations issued at some point by the City Human Rights Commission with respect to that statute. There's a few other new developments, some late-breaking things for which we don't have slides, but I do want to mention them just briefly. The first is a New York State law with respect to retirement savings, and it provides that for employers that do not have a retirement savings plan for their employees, they will have to enroll their employees in a state-run plan. There is no plan yet available for enrollment, so this statute is sort of waiting in the wings. It has been enacted, but there's really nothing for employers to do at the moment. The second development is a pending bill in the state legislature that would prohibit releases with employees that include a no reemployment clause. That's a fairly common provision in employee releases. The bill passed the state Senate in 2021, but died in the Assembly, but it has now been revived and is making its way through the process. So again, keep your eyes out for that. We will certainly push out an alert or other notice if and when that does get enacted. And then finally, for any employers on the webinar who are in the fast food industry, you may be aware that there was a statute passed in 2021 that requires just cause for termination of employees in the fast food industry. It's actually a fairly significant change enacted by the New York City Council, but it does have limited effect at this point only in that narrow industry. So with that, let me turn it over to Daniel to discuss COVID.
All right, thank you, Rob. Well, hopefully we're going to be able to touch on a variety of COVID-related topics, including the New York HERO Act, some updates we've learned there, the New York State mask mandate, some relatively new updates in that arena, the New York City vaccine mandate, and finally, the isolation and quarantine protocols currently in place under both federal and now state guidance. So let's start with the New York HERO Act. There are two different sections of the HERO Act. Section 1 is the one that has been on the forefront of New York employers' minds until recently, and has been really the one that the DOL itself has focused on, and that is the workplace safety plans. Employers were required to have adopted a safety plan, which could be either creating their own or highly recommended to just use the templates available from the New York Department of Labor. You have the link there on the slides where you can find the available templates. There's a generic one, those that are specific to 11 listed industries. Employers were required to have adopted a plan. They were then required to have distributed a safety plan to all their employees, to then have posted the safety plan in a prominent and visible place in the workplace, and then to also include the safety plan in an employee handbook if the employer has a handbook. All of these requirements were already in place and have been in place for quite some time, and we've discussed them in various webinars and other materials. Employers, those were all sort of the initial steps employers had to take, sort of what I refer to as having the plan in the back pocket, not yet having to activate it. But ever since early September, when the Commissioner of Health designated COVID as highly transmissible at the time, that triggered a requirement under the HERO Act to activate the safety plan, which means to put into place various mitigation measures, which included masking requirements, daily health screening requirements, and a training or verbal review requirement. All those have been now in place for quite some time. Again, September 6th was the first designation by the Commissioner of Health, so these various mitigation measures were activated since that point in time, where employees were required to activate their safety plans. And that designation is currently in place after several extensions through January 15th, which is obviously later this week. We expect that to be extended again, given the high case counts and of the Omicron variant spreading right now in New York. We're hopeful that if the Omicron variant follows like it has in other parts of the world, and there'll be a steep decline of cases, and we've really truly hit the peak, perhaps there will only be one more extension under the New HERO Act, but we're not holding our breaths because it's impossible to predict at this point. So that's all with respect to Section 1, just a quick refresher on that. The next slide starts talking about Section 2, which again has not been talked about as much. Section 2 refers to workplace safety committees. A later effective date, ever since November 1st of this past year, employers with 10 or more employees were required to permit their employees to form joint labor management workplace safety committees. Permit there is highlighted because employers weren't required to give employees notice of this. They weren't required to form them on their own. They were required to give permission to employees to form these. That was all that we were, in terms of how they would be established, that's all we knew under the statute. The statute also made clear that these committees would be comprised of at least 2/3 non-supervisory employees, and that those committee members would be selected by non-supervisory employees as well. Limited employer input into at least a large portion of the committee members. The committee members would be then allowed under the statute to handle a variety of topics. Number one, raise concerns regarding workplace health and safety issues, review employer workplace safety policies, participate in government site visits related to workplace health and safety concerns, and then be able to meet at least once a quarter to conduct committee business related to the topics above, and also attend trainings on the clock. Those trainings would be limited to 2 hours per year. That's all we knew about this section of the HERO Act based on the statute. We've been waiting for guidance from the Department of Labor. They promised they'd have it out before the effective date. They did not meet that deadline. But finally, on December 22nd, the Department of Labor released proposed regulations. And the next slide begins to start breaking down those proposed regulations. These are not yet in effect, but they give a lot of insight into how the Department of Labor envisions the requirements placed on employers and committee members in implementing this section of the HERO Act. So first, with respect to establishment of the committee, the proposed rule states that a committee can only be established following the submission of a written request by 2 non-supervisory employees. So if the request is submitted by 1 employee, that would not be sufficient to require the employer to permit the formation of this committee. Employers must respond to the request by 2 non-supervisory employees within reasonable promptness, though the rule does not provide a specific time frame for an employer to respond by. Finally, the rule provides that separate committees may be established for geographically distinct work sites. So that's with respect to the establishment of these committees. The proposed regulations also discuss on the next slide how committees will be, the composition of these committees. The rule sets out the minimum number of committee members at 3 and the maximum number at 12, depending on the size of the relevant work site. Irrespective of the committee's size, the committee must always have at least 2 non-supervisory employees for every employer representative. Again, that 2-to-1 ratio that the statute referenced. Where there's a CBA governing a particular work site, the union may select the employees, members for the committee. In work sites where there's no CBA, the proposed rule permits employees to select the members of the committee in any way they see fit, and also prohibits employer involvement in the selection process. What about with respect to how the committee operates? So on this slide, we see that the proposed rule allows committees to establish their own operating rules in terms of a variety of topics. Number one, procedures for selecting new members, the terms of the length of the term for those members, and the training of new members. If no procedures or rules are adopted, the committee can take action by a majority vote, again, under this proposed rule. The rule also clarifies that committee members are required to be paid for a maximum of 4 hours of committee training per calendar year, and for up to 2 hours per quarter for committee meetings. So again, that's 4 hours for committee training per calendar year, and 2 hours per quarter for committee meetings. Importantly, these rules, the proposed rules clarify that members can hold additional meetings, but not during work hours, and that whenever the committee members are working on workplace safety committee matters, aside for those quarterly meetings mentioned above, the committee members' work may not interfere with the performance of their work responsibilities. Similarly, the proposed rule makes clear that committee meetings cannot be scheduled at times that unreasonably conflict with the employer's business operations. So a little bit of a saving grace for employers if these committees would be established, just in terms of what these committee members are able to do and when they're able to do it. Again, the business operations cannot be impacted by the work of these committee members. And then finally, the proposed rules clarify on the next slide what employer obligations are. Once a committee is established, the employer must, among other items, provide written notice to all employees at a work site within 5 days of establishment of the committee at that particular site. They must respond in writing within a reasonable time period to each safety and health concern raised by the committee or a member. And the employer must provide written or electronic notice to the committee of any government site visit related to workplace safety and health concerns, so committee members know that they could, that they're entitled to participate in that. And then finally, they are required to have the ability to appoint an employer representative to the committee. That employer representative can be a non-supervisory employee, it can be an officer, or any other representative. So there's a lot of flexibility in terms of who the employer can designate to the committee. And then finally, the employer cannot interfere with the committee's performance of its authorized duties, not surprisingly. So that's what's required and incumbent upon employers. What happens now? So these proposed regulations have been published to the public. So the next steps are that the DOL will hold a public hearing on February 9th, at which they will receive public comments and feedback on its proposed regulations. If anyone on this call or otherwise is interested, you are able to register online at the DOL's HERO Act website to be able to get a time slot, a 3-minute time slot, to be able to articulate any concerns or any other thoughts with respect to the proposed regulations. As a reminder, it's not really about the wisdom of the law itself. It'd be about the thoughts and feedback with respect to the proposed regulations from the DOL. At that point, under the traditional administrative process in New York, the public will have additional 5 days to submit written comments, and then finally the DOL will take all of that, presumably consider it, and then publish final regulations at some point thereafter. Whether that's going to substantively change, obviously we'll have to wait and see from what they've already published. But we will certainly provide updates once we know more in terms of the final regulations as put out by the Department of Labor. So that's all new information with respect to what the workplace safety committees will likely look like, how they will operate, employers' obligations with respect to them. That is the New York HERO Act updates, at least for today. The next slide, we're going to talk about the New York State mask mandate. On December 10th, Governor Hochul announced that she was going to put into place a mask mandate, which required that all public places of business, not sort of employment specific here, but certainly includes employment, places of employment, all public places of business must either require proof of vaccination for anyone who enters or require masks for everyone who enters that public place of business. There's no mixing and matching options. You can't, for example, have everyone who provides proof of vaccination go unmasked and those who don't or refuse to go into the place of business masked. It has to be one or the other. Everyone has to provide proof of vaccination or everyone has to wear masks to enter. This mask mandate, so you can see the cross out, was originally designated to go through January 15th. And just a few days, which presumably was matched to the New York HERO Act designation extension as well. However, we just learned in a press briefing that the governor gave yesterday that this is actually intended to be extended through February 2nd. So that's 2 additional weeks of this mask mandate being in place. It is not yet reflected on the Department of Health's guidance that they have with respect to this mask mandate. So if you go on that website, you won't see it there. But in this press briefing, the governor has made clear that that is the expectation. So presumably we will see an extension designation put out in just a couple of days, within the next 2 days, about this extension, not just through January 15th, but through February 2nd for the mask mandate. And she said that her hope is that by that point, Omicron variant will be decreasing significantly in cases, that perhaps we could look past the mask mandate and it will no longer be necessary. So we will obviously wait and see on that front. Okay. On the next slide, we talk about the New York City vaccine mandate. So this was certainly a hot topic when it was first announced by the former Mayor de Blasio in early December. So effective December 27th, all private sector employers in New York City were required to ensure and keep records that all of their employees who are working in person in New York City have provided proof of at least 1 COVID vaccine dose or submitted a medical or religious exemption request by that date. If the employee failed to have done either of those, provide the proof of at least 1 COVID vaccine dose or submit the exemption request, then they are under the mandate not allowed to enter the workplace as of that point. The second dose, so if you're dealing with a 2-dose vaccination series, the Pfizer and the Moderna vaccination, then the second dose would need to be, proof of that second dose, would need to be provided within 45 days of when the employee received that first dose. So if they received it, so it doesn't have to be 45 days from December 27th, but it's from when the employee received the first dose, they 45 days thereafter to receive the second dose if needed, if it's not the J&J, for example, and then also to submit proof of that second dose to the employer, and the employer would then have to maintain that record as well. Employers were required by December 27th to post an attestation certificate, a template of which is on the New York City relevant website, demonstrating their compliance and attesting to their compliance with this mandate. And employers must also ensure that vendors who come to that workplace, that vendors with whom they work with send in their own employees who are in fact in compliance. So what that means is that if you have a contractor come into your workplace, you don't need to verify firsthand that or receive proof of that contractor's vaccination status. You can ask the vendor with whom you're working to ensure that any employee that they send are in compliance and have written confirmation that the employees that they in fact send are in fact in compliance. That confirmation from the contractor would be sufficient. Okay, on the next slide, talk a little bit about the accommodation options under the vaccine mandate. There's been a lot of discussion certainly on this front. The city published a standalone accommodation guidance document. Initially it was a checklist. They've amended it since then so it doesn't look as much like a checklist. Basically giving employers the information they need to walk through the analysis of analyzing an accommodation request that comes in under the vaccine mandate and when it's appropriate to grant the accommodation. With respect to medical accommodations, the guidance document lays out sort of two different subcategories, whether it's a permanent medical condition that could qualify or a temporary one. Examples of the permanent condition that could qualify would be an allergic reaction to a prior dose or a known an allergic reaction to an ingredient in the vaccine. With respect to temporary conditions, the guidance lists that anyone who has received monoclonal antibody treatments within the past 90 days are otherwise immunocompromised, or and this is not in the guidance itself, but the hotline confirmed, the New York City hotline confirmed for us that if someone had a recent COVID diagnosis and their doctor has in writing that they can't receive the vaccine for a specific period of time thereafter, those would qualify for potential temporary accommodations under the law. What are the accommodations that are available? So the guidance lists out a few different options. The main one that's most likely to be relevant is weekly PCR testing plus masking. Again, masking is going to be required anyway right now under the New York City mask mandate, but also potentially under the HERO Act. And the other options available are working remotely, putting the employee on a leave of absence, and then the guidance lists out other and sort of gives a blank, which suggests that they recognize that there could be alternative accommodation options and provides employers with some flexibility here in terms of finding ways that they don't have to discipline or otherwise put their non-compliant employees, employees who are getting entitled to an accommodation to not have to put them on a leave of absence, or if they can't telework and are unable to test for some reason, there might be some other alternatives that are available to employers. So some creativity is apparently allowed for under the New York City guidance. The next slide just talks about the likelihood and risks of enforcement. So the guidance that came out states that penalties for failing to comply, for employers who fail to comply, are $1,000 for the first violation with escalating penalties thereafter. The risk of enforcement, however, does not appear to be particularly high. In the guidance itself that was published under the de Blasio administration, it says there, you see it in the second bullet, our goal is always to educate and work with businesses to help them achieve compliance. It's always our preference to ensure compliance and to avoid fines and penalties. So even when under the administration that enacted the vaccine mandate, it wasn't clear that they were looking to penalize as much as they were looking to educate and ensure compliance. There was question whether the current Adams administration was going to continue the vaccine mandate when he took office. He did, in fact, announce that he was going to continue it, but again, even more so, emphasize that they're looking to be cooperative with employers and not punitive. So, again, a little bit of a risk analysis, risk assessment might be in order, but we went over the details of what's required under the vaccine mandate are again, we spoke about them here. There's more details available on the New York City vaccine mandate website. But just a little bit of information in terms of understanding the penalties and the risk of enforcement. Just quickly, also somewhat late breaking news here, we were talking about the New York City vaccine mandate. In New York State, there's no private sector or general private sector vaccine mandate, but there is one in place for healthcare workers. Just yesterday, the New York City Department of Health, following an announcement by the governor just a few days prior, confirmed that there actually will be a mandated booster in the healthcare industry for all healthcare workers. So that is going to be put into place, I think effective already today. It just pretty late breaking news. We don't have it in the slides, but if you're in the healthcare industry, just be on the lookout for updates. We might be in the works of getting an update out right now on that, but just to be aware that in the healthcare industry in particular, there is now the booster shot would be required in addition to the other vaccination shots the employee might have received under the existing mandate. And then just very quickly, I want to talk about the isolation and quarantine protocols. There was a lot of discussion recently with the CDC having revised and decreased the relevant time periods necessary for someone to isolate and someone to quarantine. To be clear, isolation refers to someone who actually contracts COVID. Quarantine refers to someone who was exposed to someone else who tested positive for COVID. So with respect to isolation, someone who has COVID, in order to be able to exit isolation, so first of all, New York State adopted the CDC's approach, which is to decrease the time for isolation down to just 5 days. And at the end of that 5-day isolation period, it depends on a variety of factors, whether you can exit isolation at that 5-day mark. If the individual is asymptomatic or the symptoms are generally resolving and there aren't any particularly heavy symptoms like a very strong cough that has phlegm or a runny nose, then that individual can exit isolation and should wear a well-fitting mask when around others for 5 more days to get to the 10-day mark. If employee is either immunocompromised or unable or unwilling to wear a mask for those additional 5 days, then they actually have to remain in isolation for the full 10-day period that was in place until now. So that's with respect to isolation under both, again, CDC guidance and the New York State Department of Health. The final slide just talks about quarantining. So again, that's when someone is exposed to someone who has COVID. So here it actually depends on the vaccination status. With respect to isolation, there was no differentiation once you get COVID, whether you're vaccinated or not, in terms of when you could exit isolation. But in the quarantine context, it does depend on vaccination status. If someone who is not fully vaccinated or not yet boosted, if you're eligible for the booster, then someone who's exposed to COVID must quarantine for 5 days after exposure and then wear a mask for an additional 5 days. Those who are fully vaccinated and boosted, if eligible for the booster shot, and they're asymptomatic, they do not need to quarantine at all, according, again, to the recent CDC and New York State guidance. Noting there that under this sort of new guidance, while the definition maybe of fully vaccinated hasn't changed, if someone is eligible for the booster and they have not received it, they're treated essentially like someone who is not either fully vaccinated or not vaccinated at all. That's an interesting change out from both the CDC and the New York State. The testing is not required to exit quarantine or isolation, but it is a recommended step, but is not required, and that was certainly a lot of hot topic of debate with respect to the CDC's changing guidance. So again, we covered what the updates with respect to the New York HERO Act, the New York State mask mandate, the New York City vaccine mandate, and now the recent revised isolation and quarantine protocols under New York State and New York and at the federal level. A lot of information, a lot of changes, and we'll continue to monitor these as we go forward.
All right, Daniel, thank you so much for that overview of COVID protocols. Certainly important issues and top of mind issues for us, and we'll continue to monitor those. So let's talk about some recent developments on the whistleblower front in New York. Next slide, please. Earlier this year, the New York whistleblower law was amended, and it goes into effect January 26th. The importance of this law is how severe the amendment really is, or how extensive the changes are. It's interesting because prior to these changes, I think I've often characterized the law as, unless we have an employee who is reporting the fact that chemicals are being dumped in a river and populations are dying, as kind of an example, the New York whistleblower law really did not offer a tremendous amount of protections to employees as whistleblowers. As of later this month, that's going to change. We'll talk about a couple of the high-level changes here today, but we do want to mention that we have a program later this month titled the Expanded New York Whistleblower Protections, What Employers Need to Know, that will take place on January 25th. That will be a much longer program, and it'll be specifically dedicated to this statute. But just kind of as a brief overview to get us started, excuse me. One of the major changes here, two of which are noted on the slide, is the definition of employee. The employee will now include former employees and independent contractors, so a much broader population of individuals than just current employees. The second very major change is what constitutes a protected activity under this law. Protected activity will now include any disclosure or threatening to disclose to a supervisor or public body. So just to kind of backtrack, as we have it highlighted on the slide, disclose or threaten to disclose. An employee can report something or threaten to report something, they haven't done it yet, to a supervisor or a public body. It can be an internal report or an external report. They can report it to someone internally or externally to a public agency or enforcement agency. Any activity, policy, or practice, another broad reference, to anything that the employee, quote unquote, reasonably believes violates any law, rule, or regulation. Doesn't have to be an actual violation of the law. The employee just has to have a reasonable belief that it is, or something that poses a substantial and specific danger to public health and safety. And that is, although part of the amendment, that harkens back to what the original statute was. So what protected activity is actually much more broad now than it has been before. Next slide, please. Next slide, please. Sorry, we'll stay on this one. The law used to provide for a notice requirement. Employees would be required to make a good faith effort to notify the employer before disclosing anything to a public body to qualify for whistleblower protections. But that will no longer be required in certain situations. For example, if there's an imminent danger to public safety, if an employee reasonably believes that the employer will destroy evidence, if the employee believes that there's a physical harm that would result to them, or if the employee reasonably believes that the employer is already aware of the alleged activity and will not correct it. So these exemptions are really quite broad as well, that alleviate the need for a let's say, notification to the employer and an opportunity to correct it. So an employee does not actually have to have a notification in those circumstances. Next slide, please. These changes, although noteworthy, are not necessarily as monumental. Prohibited retaliation, as we might expect, includes actual threatened termination, suspension, or demotion, or any adverse impact on any terms and conditions of employment. It also adds a relatively broad catch-all, any action that would adversely impact a former employee's current or future employment. This catch-all is very broadly worded and presumably captures a tremendous amount of potential activity that does not directly impact terms and conditions. The last prohibited form of retaliation is contacting or threatening to contact the immigration authorities to report the employee or their family members. Next slide, please. The statute of limitations will be increased to 2 years, although the law currently has provided injunctive relief, reinstatement, lost wages, attorney's fees, and several other remedies. It will now be amended to include the opportunity for jury trials, front pay in lieu of reinstatement, punitive damages in certain circumstances, and civil penalties. One important feature of this law is that in instances of frivolous litigation, generally defined as claims by employees that are not supported by the facts or do not support any reasonable argument for an expansion of the law, there is an opportunity for an employer to be awarded reasonable attorney's fees. While an important component of this law, remains to be seen as to how that will play out in practice in most instances, considering the broad definitions under the law. Next slide, please. And the last thing we wanted to mention briefly is that there is a posting requirement. New York's Department of Labor is expected to issue a model notice by January 26th. And that is supposed to be posted in a conspicuously and easily accessible, well-lit place that is customarily frequented by employees and applicants. So that is a quick overview of the new whistleblower protections available in New York State. Next slide, please. Let's talk briefly about the New York City's amendment to the Fair Chance Act that took place in July of 2021, as well as some guidance that we received in November of 2021. Incredibly important component to this law. This is arguably the most protective criminal background check statute in the country. Surpasses whatever is required in California or San Francisco or any of the jurisdictions across the country. The very biggest of which of these requirements is that New York City now requires a two-step criminal background check process. The way that the law envisions background checks will be conducted is that during the interview process, step one will capture all non-criminal information. So in other words, a company will run a background check for non-criminal information such as employment verifications, academic and educational history, drug tests, social security traces, reference checks, etc. Once all non-criminal information is collected and considered, the employer is then supposed to give a conditional offer of employment conditioned only on the results of a criminal background check and potentially an exam under the Americans with Disabilities Act. We're not really talking about that for purpose of this discussion. We're really sticking to the criminal background check component. It is only after that conditional offer of employment that an employer is for the first time able to inquire about any sort of criminal history about an applicant. Now, when I say inquire, I do mean a formal criminal background check, but that also includes any questions to the employee directly and any type of other search. So, for example, Googling someone to find out whether they have any criminal history would be included in that. This new setup implicates whether or not an employer would be required to give two sets of disclosure and authorization forms under the Fair Credit Reporting Act. The New York City Commission has taken the positions that if the employer makes some modifications to those forms, they might be able to use one set. It's unclear whether that is actually a workable solution. There is an argument that two sets of forms would have to be used, one at the non-criminal stage and one at the criminal stage, because both of them are defined as background checks under the federal law. Next slide, please. The New York City Commission has said that for employers that cannot or don't want to do the two-step background check process, they can do a single step, so a one background check process, but only if all of the criminal information that is collected during that process is segregated from the knowledge of any decision maker or anyone who's involved in the hiring decision, and that the employer has the burden of proof to show that anyone who made the decision to hire was not privy to any of that information until after the conditional offer of employment was made. It is a complex way of handling this. There are risks involved, and if this is something that any employer is interested in doing, they'd be well advised to speak to someone about this, to speak to outside counsel or anybody that they're consulting with about this to figure out how that can work. Next slide, please. We often get asked the question of, well, why can't I just do a background check with all the information at the last stage after the conditional offer like we do in many other jurisdictions? Well, the reason is that the New York City Commission has come out to say that that is explicitly not what they have in mind, that they want all non-criminal information to be handled first, and any employer who is seeking to disqualify an applicant after the conditional offer will be presumed to be doing it for the reasons tied to a criminal background check, and will be up to the employer to prove otherwise. So any employer that's taking that action post-conditional offer on non-criminal information will have to prove that it could not reasonably have known the information before the conditional offer. We read that to basically mean that the information was not available at all, even if they had performed a background check, and that regardless of the criminal background check, they would have taken that action anyway, setting the bar relatively high for an employer that is in that position having to prove that. Next slide, please. The New York Fair Chance Act now also limits how much information can be obtained about non-convictions, and that those non-convictions should not be considered. So, for example, things like criminal charges that have been adjourned in contemplation of dismissal, charges that have been terminated in favor of the individual, or charges that have been pled down to non-misdemeanor or felonies. Equivalent charges in other jurisdictions will be treated the same way by New York City. Next slide, please. It's important to reiterate, and this has been the law since 2015, but it bears reiterating because the Commission has given some further guidance on this. There can be no reference whatsoever to a criminal background check throughout the employment process, so job ads, interviews, applications, anywhere, until the conditional offer of employment. And I intentionally said criminal background check because you can obviously ask about non-criminal information prior to that stage, but any reference to criminal background checks. The Commission has said that employers can use quote unquote people first language, such as people with criminal histories are encouraged to apply. However, they have unambiguously said that statements that seem neutral, such as criminal history will be considered consistent with the requirements of the New York City Fair Chance Act, are not permitted. This type of language is oftentimes seen in other jurisdictions. It is expressly prohibited here. A quick note, any employer that is operating in New York City and San Francisco, the two ordinances conflict, and oftentimes there can be no one document that complies with both sets of laws because they have directly opposite requirements, and that San Francisco requires a disclosure, New York City expressly prohibits a disclosure. Next slide, please. So inadvertent disclosures, the New York City Commission has given us a little bit more guidance on that. What do we do when an employee or an applicant blurts out during a interview, I just want you to know I have a criminal background, I have these criminal charges that are pending, I have this conviction. The Commission has said that in those types of instances, the employer should state that the applicant's record will be considered after a conditional offer, and at that point, basically change the subject. It will effectively be the employer's burden to show that that process was followed, but the Commission does give a little bit of guidance as to how that should be handled. Next slide, please. Let's talk about intentional misrepresentations, or when applicants and employees lie about their criminal backgrounds. So the Commission has raised the bar on this as well, is that they're only concerned with intentional misrepresentations. Situations where the employee or applicant knows that the information is false and they are intentionally looking to deceive the employer anyway. Before taking any action, the employer is supposed to give the applicant whatever information that the employer has to show that it was a misrepresentation, and give the employee 5 days to set the record straight and either show that it was unintentional, or that they were confused, or that there's some other explanation. If they do that, we're back at square one. That information cannot be the basis for an adverse employment action. Next slide, please. In withdrawing a conditional offer, the Commission has also given us a couple of steps that are generally required. So, for example, first, the applicant has to be provided with everything that the employer considered. Number two, there has to be a written copy of a fair chance analysis. That is a form that's provided by the Commission, and it could be done in writing in another form, but following certain factors that we'll discuss in a second. And the applicant has to be given 5 business days from the time that they received that information. So the Commission actually recommends that the employer and the employee coordinate and consent to the form of communication that will be typically electronic is fine, so long as the employee agrees to it. That job that the employee is, or that the applicant is applying for, cannot be permanently given to someone else during that time. And for current employees, the law allows for unpaid leave for approximately 5 days while that process is being followed. Next slide, please. The Fair Chance Act has also been amended to provide 2 different sets of factors during that fair chance process. We won't go through them in detail here, but they're listed on the screen. Pre-employment, there's 1 set of factors. These refer back to New York Corrections Law, Article 23A, and New York City Ordinance now requires a slightly modified set of factors for current employees prior to any adverse action on the basis of a criminal background. Next slide, please. Important note to temp agencies, before a temp agency puts somebody into their labor pool, they're allowed to run a criminal background check and follow the fair chance process. And when the employee is placed at an employer, they can follow that process as well. Both times, the full fair chance process as outlined with the 2 steps, and all these protections have to be followed. Quick note to temp agencies, there is a basis for aiding and abetting liability that we did want to make a mention of. Next slide, please. Do we have any exemptions? Yes, there are exemptions where background checks are required. At that stage or in those circumstances, an employer may not need to follow a two-step process and can do the criminal background check as one check. In instances where certain convictions or certain positions prohibit the employment of people with certain convictions, it's nuanced, but typically the commission takes the position that, for example, if there's a position that prohibits crimes of moral turpitude or financial fraud or something like that, those crimes can be researched at stage one, but any other crimes that do not fill that description have to wait until the second stage of the process. This typically impacts financial institutions and a couple other industries. And we'd be happy to talk about that in a little bit more detail offline. If an exemption applies, next slide, please. The commission has a process. There should be a written record of that. The record should be kept for 3 years. The commission, if there's a challenge to this, the commission will request an exemption log, and any type of inquiry into the criminal history, the commission recommends should be kept separately from an employee's personnel file. Next slide, please. As far as enforcement, the commission has been, especially in the past few years, a vigorous enforcer of this law. Just to make a quick reference here, civil penalties are based on the size of the employer and a couple other factors. Civil penalties can range up to 125 per violation. For willful and wanton malicious actions, they can go up to 250. And these are on top of any other remedies that the New York City Commission can award. These can be pretty significant. So let me turn this over to a discussion on leave law updates. I'll be back in a few minutes to wrap up with updates on cannabis law. Thanks so much, and happy to answer any questions offline that may come up.
Thank you very much, Rob. So I'll be briefly talking about leave law updates in New York State and New York City concerning vaccine leave laws, as well as some New York paid family leave updates. So in this first slide, we're going to see the New York State COVID-19 vaccine leave law. This went into effect on March 12th of 2021 and is currently scheduled to sunset on December 31st, 2022. The covered employers and eligible employee standards are very broad. They apply the New York labor law standards, so essentially all employers, regardless of size, are covered, and all employees are covered. This leave provided under this law is in order for the employee to take leave to get their own vaccine injection. It is not for the employee to accompany any family member or anyone else to get their vaccine. It is for their vaccine only. Employees are supposed to get a sufficient amount of time to get their vaccine injection, not to exceed 4 hours per vaccine injection. So if an employee is getting a vaccine, either Pfizer or Moderna, that have 2 shots, they're entitled to 8 hours for those 2 shots. If they're eligible for the booster shot, they can get an additional 4 hours. So as it stands right now, employees can get up to 12 hours, depending on what vaccine they take. So the rate of pay under this law is the employee's regular rate of pay, so they're entitled to that rate when they take leave under this law. In terms of notice and documentation, there was nothing in the law addressing these. However, the FAQs provided that the law does not prevent employers from requiring reasonable notice or reasonable documentation. However, employers have to be mindful to consider confidentiality requirements applicable to the records that they're requesting for the proof of vaccination. Now, one very important thing, and a question that we got a lot about this is, well, what if I already have a paid sick leave policy or a PTO policy and I already give employees vacation another time? Do I need to give this in addition to those? And the answer is yes. So this leave, the law specifically says, cannot be charged against any other leave that the employee is entitled to, including leave pursuant to the New York State non-COVID-19 general paid sick leave law, and it has to be in addition to any other leave provided by the company or any leave provided to the collective bargaining agreement. So you should be sure that employees are getting this as an additional leave to other company policies that exist. And with that, next we're going to talk about the New York City child vaccine leave mandate. So one thing that's different about the New York City child vaccine leave mandate is that unlike the New York State one, which was a separate mandate, completely separate from any other laws, New York City amended its already existing Earned Safe and Sick Time Act in order to add this additional leave. This mandate went into effect on December 23rd, 2021. However, it has retroactive effect to November 2nd, 2021. So if you had any employees who used leave that would be covered under this between November 2nd and the effective date of the law, make sure to go back and provide them with this additional leave. Just like New York State, employer coverage and employee eligibility under this mandate are very broad. So it applies essentially to all employers and all employees. The leave is provided to employees in order to take their child who's under 18 years of age or a child who's older but incapable of self-care because of a mental or physical disability, to accompany their child to receive a COVID-19 vaccine injection, or to care for their child after the child has gotten the vaccine but is experiencing any temporary side effects of the vaccine. Under this law, employees get 4 hours of COVID-19 child vaccination time per vaccine injection for each child. So once children become eligible for the booster, employees can receive up to 12 hours of time per child. The rate of pay, again, is the regular rate of pay. In terms of notice and documentation, this standard is unchanged, so you should continue to follow the Earned Safe and Sick Times Act notice and documentation standard under this law. This leave is also in addition to the leave that you may already be providing under the New York City Earned Safe and Sick Time Act. So even if you are providing the 40 or 56 hours, depending on the employer size, you have to give this leave in addition to that. One important thing is, although the law does not specifically say whether you have to have a written policy of this specific mandate, because it amended the New York City Earned Safe and Sick Time Act, which does require written policy, most likely you will need to amend your policies to add this. Now, in the next slide, I'm not going to go over this one in detail at all, but you'll see a reminder that in addition to the vaccine laws that I just discussed, we have the New York COVID-19 emergency paid sick leave law that's still in effect, as well as the New York State and New York City general paid sick leave laws. One thing to note is that in the last couple of weeks, New York State released final regulations for the New York State general paid sick leave law, so make sure to update your policies to address those changes. And now finally, on the last slide of this section, I'm going to address some quick updates regarding New York paid family leave law. So although this law has been around for a while, effective January 1st, 2023, so you have some time with this, employees will be able to take paid family leave to take care of a sibling with a serious health condition. So what the amendment did is it added sibling to the covered family members in this law. Some other updates for you there. Employees are still entitled to 12 weeks of leave and still at the 67% rate. However, given that the state average weekly wage has gone up, the monetary benefits that employees can receive have gone up as well, as has employee contribution. One more important note here is that the state released a 2022 version of the Statement of Rights, so be sure to give that up-to-date notice to your employees. And with that, I'll pass it on to Rob to wrap us up.
Marlon, thank you so much. And I realize that we're running a little short on time. Let me give the CLE code very fast. The CLE code is SS6372. SS, as in Seyfarth Shaw, 6372. Since we're running short on time, we will go over by a couple of minutes to capture the cannabis update, but we'll move quickly through the slides. So in 2021, New York State passed the Marijuana Regulation and Taxation Act, which legalized the sale and use of cannabis for adults 21 and over. Effectively, the law created protection under New York's off-duty conduct statute for employers. So Labor Law 21D, which protects and protected things like smoking, certain political activities, etc., now also protects use of cannabis by employees. Next slide, please. The law describes who is protected. So employees, both private and public sector, immigration status doesn't really matter so long as they're an employee, but it does not protect students, independent contractors, volunteers, folks that are working out of familial obligations, or employees under 21 years of age because they're not lawfully using cannabis under this law. Next slide, please. New York State's Department of Labor issued some FAQs that kind of gave a little clarity to some of these requirements. First of which is drug testing. According to the New York Department of Labor, they interpret the law to prohibit drug testing for cannabis or marijuana. It's not explicitly in the statute, but effectively, if you're not allowed to rely on that information pre-employment or anything like that, that effectively prohibits testing. In New York City, there is a law that explicitly prohibits testing, but the rest of New York State will fall under the New York State's Departments of Labor interpretation. In instances where there is a law that specifically requires testing, for example, with commercial vehicle drivers, employers are allowed to test. But part of the DOL's reasoning is that there is no reliable testing method in the market right now that can reliably show that someone is impaired or has been using cannabis on the spot. Usually it's 30 days, 90 days, et cetera, for certain tests. This year may see the release of certain technologies that allow for things such as a breathalyzer, but that remains to, that's on the horizon. Next slide, please. If an employer has an employee who is using cannabis on the job, what can the employer do? Well, the employer can take an adverse employment action only in situations where the employee manifests specific articulable symptoms of impairment that decrease or lessen the employee's performance or interfere with the employer's obligation to provide a safe and healthy workplace. What are specifically articulable symptoms? The Department of Labor says they're objectively observable indications that someone's performance of their job duties is decreased or lessened. It's we'll know it when we see it kind of test. They give the example of somebody who's operating heavy machinery in a sloppy or unsafe manner. Something like that would likely suffice. The objective observable indication cannot be a drug test. They reiterate that here. They also caution that certain symptoms or indicators can also be indicators of disability for certain employees. What's the net result of that? Just to make an important point is that you can have an employee who is physiologically impaired from cannabis at work who would not face discipline because they're performing their job duties in a way where they're not manifesting any articulable symptoms and their job performance is just fine. If they've been using cannabis, but they're working just fine, the employer would not be in a position to take any action based on that. Next slide, please. An important note is that an employer can have certain policies that, for example, prohibit cannabis use during work hours. What are work hours? Any time that the employee is actually engaged in work, which includes paid and unpaid breaks, so lunch, coffee breaks, etc. And an employer can prohibit cannabis possession at work. What does the work site include? Any physical property of the employer, the office, the surrounding areas, parking lots, etc., lockers, desks. Vehicles, if somebody is issued a company vehicle, even after hours, cannabis possession can be prohibited, but it does not extend to a remote work location. So if somebody is working from their home, an employer cannot prohibit someone from possessing cannabis at their home. Next slide, please. Employer policies also cannot prohibit use outside of the workplace unless there's some requirement under some other law. So for example, CDL drivers, perhaps outside employer policy cannot regulate what happens outside of work. Again, this was an amendment to New York State's off-duty conduct law. Also, an employer cannot circumvent the law by having an employee to agree or promised to not use cannabis as a condition of employment. Next slide, please. What's interesting is that New York state law now kind of creates a little bit of a rub because the National Safety Council has recommended a zero tolerance policy for cannabis for years. They base that on the general decline of judgment and motor skills for employees, an increase in accidents, injuries, and fatalities. They've done research, showing that after workplace fatalities, a large percentage of postmortem toxicology reports have shown cannabis impairment. Labor law 201D does not have any safety sensitive exemption. The only thing that it relies upon are really the specific articulable symptoms of impairment. So there is no specific safety sensitive exemption under New York state law for cannabis use. Next slide, please. And this will be our last slide. We'll wrap up here. What about remote workers? We're seeing a huge uptick in remote workers, especially in the last 2 years. How does this impact folks that are working from home or remotely? Well, New York Department of Labor explains that New York state law applies within New York State. So employees working within New York State would be covered, but out-of-state workers likely not covered by the law. They may have independent protections under their respective state laws. For example, New Jersey and other jurisdictions where people may be working remotely from may have protections, but New York state law would not extend so far. With that, next slide, please, to say thank you. Thank you for sticking with us. I'm sorry that we ran over by a few minutes, but we did want to capture those last couple of points. Thank you to all our speakers today, Rob Whitman, Daniel Small, Marlon Duro. Fantastic job. A lot of insights on a lot of important developments in New York state law. Both in 2021 and on the horizon for 2022. We thank you so much for sticking
to it. If I could just jump in, thank you, Rob, and thanks everybody on the panel. But just for those of you remaining with some late breaking news, it happened literally as we were in the middle of our webinar. I heard from a participant following Twitter that the Supreme Court has blocked the OSHA emergency temporary standard regarding the vaccine mandate. So that's not a huge surprise to those of us who were following it and who paid attention to the oral argument. But just so you heard it here first, the OSHA standard has been stayed. That's not an ultimate ruling on the merits, but just a stay. For those of you in New York City, the city mandate remains in place, but outside of New York City, unless there is another government mandate at the local or state level, the federal standard has been blocked. So with that, thank you all for attending. Look forward to seeing you through the year, and feel free to reach out with any questions or follow-up. Have a great day.